SJC-11654, Patricia Campatelli v. Paula M. Carey and others.
Fran, will you sign this for me?
Yes.
Thank you.
With the court's permission. Good morning, Your Honors. My name is Attorney Philip Boncory. Together with co-counsel Jeffrey Rosario Turco, we represent the elected registrar of probate and insolvency for Suffolk County, Patricia Campatelli, who's in the courtroom as well. We are here, Your Honor, to right what we believe is a wrong. We came before the single justice for Suffolk County with a verified complaint seeking some kind of equitable relief because Ms. Campatelli had been suspended on 3 occasions. The first in December of this past year, 2013, December 20th, then again on January 15th of this year, and finally, she was again suspended but placed on administrative leave, calling that not a suspension, on March 5th of 2014. We filed a verified complaint asking for relief. We came before the single Justice Duffley, who observed this case, and reported it to the court to answer all questions. We're before the court today asking the court for a ruling that neither the Chief Justice, the court administrator, nor the Chief Justice of the divisions have the authority to suspend, terminate, or place on paid administrative leave a elected...
Let me ask you this.
Yeah.
Does anyone have the authority to do that?
Only this court, Your Honor, and a majority of this court. And I believe that was made very clear, and it's been the law for the past 160
Are you
years.
suggesting that even if it is the ultimate authority of this court to dismiss,
Correct.
that's subsidiary to that? There is no one else who can do what was happening in this case, essentially, which is to place on leave, paid leave,
Correct.
during a period of investigation. No one but this court can do that. That's your position.
My position is that no one but this court can do it. I
And
think,
your authority for that is?
my authority for that was, Your Honor, in the opinions of the justices to the Senate in 1977, this court determined that the repository of any inherent powers of the judicial administration is in this full court.
So do you say then that the statute that was enacted that has now made the amendments to sections 9 and 10, that under which the court administrator and the Chief Justice of the trial court and the Chief Justice of the probate and family court, those particular provisions don't mean what they say? Or that they're unconstitutional?
No, I believe they all mean what they say. However, every one of those sections, whether it's Section 9, Section 9A, or Section 10, all have language in them that says nothing in this section shall authorize the exercise of power that is reserved to the full court. They further go on and say in each of those sections that the provisions of those sections should not apply to a clerk, magistrate, registrar of probate, or reporter who's been elected or appointed by the governor.
So it's the last
It's the last
line
romanette
of
in
that.
each of those
The
three
last
sections,
clause of
9,
each of
9A, and
those.
10, which clearly make it the power of this court.
Well, isn't there some kind of implicit, inherent authority that lies in the Chief Justice and the court administrator to discipline people, anyone who works in the court system?
Well, the very concept of inherent power means that it is used when there is no other alternative method to resolve a situation.
So if the clerk of the court opens court every morning by saying, don't listen to the judge, he doesn't know what he's talking about, the judge can't order the clerk out of the courtroom?
I believe the first justice in the courtroom would probably have some authority to talk to the...
How about the judge on the bench? A visiting judge from across the state?
Your Honor, I believe that they do not have that authority. I believe that authority has got to come from this court. And there are ways to get to this court quickly. I mean, if there is a disruption between a first justice and a clerk of the court. There is a situation for that. That's in the statute. There is no statutory authority for a chief justice come directly to a clerk and have that clerk suspended.
Right, but the question I think Chief Justice Ireland asked you was whether there isn't some inherent authority, put the statutes aside, some
Okay.
inherent authority that just goes with the function of the judicial branch to maintain order in the courtroom, to do a lot of different things. But in Justice Spina's example, you would say that the presiding judge would not have the authority to tell that clerk, you can't do that?
I believe they would be able to ask them to leave the room and bring in another assistant, absolutely. I believe they have that authority in the courtroom to make sure that courtroom is run correctly. I don't believe they have the inherent authority to terminate, suspend, or put on paid leave a clerk.
But
There's a big
we're only
difference there.
talking about suspend unpaid leave. I mean, termination really isn't at issue in this case, correct?
Termination is not an issue in this case, but I believe all of the cases that we have researched state that termination goes along with the right to suspend. If you have the right to terminate, you have the right to suspend.
But you're suggesting that just having that right, because it's within the broader power, that doesn't necessarily mean that someone else doesn't have the lesser power, divorced from the greater power. Wouldn't you agree?
No, I believe the lesser power would still have to come before this court in the course of a paid administrative leave or a suspension.
Now, Mr. Boncory, you say that Section 9, 9A, and Section 10 have the language that speaks of this provision shall not apply to a clerk or clerk magistrate or register of probate, but I could find that language only in 9A and 10. I could not find that language in Section 9, which pertains to the authority of the Chief Justice of the trial court, and that has the subprovision 23, which expressly gives the Chief Justice of the trial court, quote, the authority to exercise any inherently judicial power not otherwise specified in this section, provided, however, that nothing in this section shall authorize the Chief Justice to exercise any power reserved to the full court.
Correct. And I believe it's that last sentence that says nothing in this section shall authorize the Chief Justice to exercise power that's reserved to the full court. And this power to suspend is reserved to this full
Okay,
court.
so with regard to that provision, that argument depends upon us concluding that the power to suspend with pay is reserved to the full court.
Correct.
Mr. Boncory, is there any level of discipline that can be imposed on an elected official in the judicial branch other than what can be imposed by this court?
I am concerned about that because in Section 10C, it says that the administrative judges have no power over the hiring and the clerks, registrars, and people in that category,
Right.
the category of my client. So I believe that there is a question there that should be answered by this court,
What's the answer?
Any level of discipline would have to be imposed by this court.
by this court. Absolutely.
And a reassignment.
I think well, especially an elected official.
what we-
Our position is that an elected official is not an employee of the Chief Justice. She's an employee of the citizens of the Commonwealth of Massachusetts, of Suffolk County.
But we're all
elected.
employees of the people of the Commonwealth of Massachusetts.
We're all employees of the people of the Commonwealth, but an elected official should be a peer to the justice that has been appointed to oversee. I mean, it's not a subordinate position. They should be able to sit, talk, work things out if there's a problem.
So your position is that the Chief Justice can suspend every other employee in the judiciary but elected officials?
Correct. And I think the
They have
statute-
special status.
They do, because they are elected, they are put there by the people, they answer to the people. And
So that would mean that hypothetically, an elected official could decide, I'm only going to show up at work at 2 o'clock every day, and there's nothing that the Chief Justice could do about that. That's your position.
My position is that the Chief Justice could sit down and talk with them, get that person some education, work out an agreement. That is what intelligent people do. They sit together and work out agreements. Countries do it.
Is it at
The
that
legislators
point,
do
if there isn't an agreement, becomes a dispute, that then becomes something that they can,
Yeah,
they
but
can then
in this case,
address?
there were no complaints. There was no dispute between the first justice and the clerk. The court was running.
But,
There were no formal complaints ever brought.
so though, does your client challenge the application of the code governing clerks?
Oh, no, not whatsoever.
Because it covers elected as well as appointed clerks
Correct,
and registers.
correct. And there is a
So
process.
she sees herself as being bound by that code.
Oh, absolutely. And there is a process in dealing with that code. And that process is either you come here under a Section 4 petition, or you go to the Clerks Committee for a hearing. And there's due process.
But
Just suspending someone, or even putting them on a paid administrative leave, is not giving that person any due process whatsoever.
But you're saying, I take it, that the Chief Justice of the probate court or the Chief Justice of the trial court could petition us under 211-4 for the temporary removal or of duties pending an investigation.
Correct. But it would be for a summary hearing here.
Could we
that could be-
delegate that responsibility that you say we have to the chief if we chose to?
I believe you could do that by statute. I don't know if you could do that just in delegation, because it's already legislature there that sets the exact procedure to do these things. And that wasn't followed in this case.
What's the remedy you're looking for?
The remedy we're looking for is a ruling that they did not have the ability to suspend her, and that she is allowed to go back to work. Every day that she's out of work, the people of Suffolk County are losing their voice in the probate and family court, a voice they put there with 200,000 votes. She is their voice to run that probate court, and she's not there. We'd be asking for an expedited judgment so that she can get back there. And that is the one thing we're looking for.
But did they elect her to carry out her duties in any way she deemed fit, or in a manner that was consistent with law?
Absolutely in a manner that was consistent in the law. And for the
And
year,
if the elected official does not carry out duties in a manner that's consistent with law, in fact, in flagrant disregard of law, there's no other way to remove the person temporarily?
well, that's not the issue in this case, because for the year that she was in office, that office was run well. There was no complaint from the first justice. There was no formal complaint. In fact, there's never been a complaint against Patricia Campatelli in her 30-something years of working for the state.
So if an elected register tells everybody that's working in the probate court that we're going to begin work every day, you get on your hands and knees and bow down to me, and then we'll go back to work, and nobody complains about it except for the employees, that's okay.
Of course, that's okay, but that's not what happened in this case. In this case, she was there every day. She dealt with her clients.
It's a point that we don't know what happened and that this is being investigated, that at this point there are allegations. There's been an investigation, and there's now an ongoing investigation. And I thought the issue was, isn't it okay, as inherent power of the chief, to suspend with pay, with full pay, during the pendency of an investigation into serious allegations? We're not saying what happened. We're saying
Well, I take
these
it your answer is that, of course, there's that power, but it lies here, and it cannot be delegated anywhere
It lies here
else.
with this court and not with the Chief Justice. I mean, in that 1977 opinion of justices to the Senate, when they attempted to make the Chief Justice of this court the sole decider, this court ruled that that would be ineffective. It's for the full court. And I believe that this suspension, or anything that is an adverse decision, and that's your adverse action. And my brother's brief says this is not punitive, but it is punitive.
So there's no, again.
She's out of the office and told you can't walk into your own office. You can't talk to your own employees. That's punitive. There's, to say it otherwise is nonsensical.
Knowing that what we now know as a result of having read what we read, can we act on our own initiative?
Yes, you can.
And
Yes, you
so
can.
if we thought it was appropriate to suspend your client with pay pending the investigation by the Clerks Committee, we could simply do that right now.
I believe you could do that in a summary hearing, yes.
Could I just ask one question? Are you saying, I just want to make sure I understood you correctly, are you saying that your argument really applies because Ms. Campatelli is elected, but so that a clerk of a district court appointed by the governor could be suspended, but an elected clerk cannot? Is that where you are?
I don't believe that appointed clerk could be suspended either without a hearing, without due process, without some process, whether it be before the Clerks Committee or be it before this court.
But Section 10C lumps clerks or registers of probate together.
Yes, it does.
So, I mean, if you say we have to go by the wording, the plain meaning of the words of the statute, it seems to me that your answer to Justice Botsford's question has to be, yes, it applies the same to.
Yes, that's what I just said. It does apply.
But the hearing takes place here, you're saying?
You can determine two ways to conduct a hearing. You can take a hearing here after a complaint has been filed here, after that complaint has been given to the clerk, or whether appointed or elected. That clerk has an opportunity to answer that complaint, and you can have a summary hearing here. Or it can be sent to the Clerks Committee for hearings, and the Clerks Committee recommendation, hearing officer's recommendation would come back to this court, and then this court would make an informed decision.
Counsel, your time is up. Thank you very much.
Thank you very much, Your Honors.
Chief Justice Ireland, members of the court, may it please the court, my name is Peter Haley. I'm here this morning on behalf of the Association of Magistrates and Clerks as amicus in this proceeding in response to the court's announcement. In Turner versus the City Council of Boston, this court held in 2012 that the removal or suspension of a public officer requires a specific constitutional or legislative authorization. No such authorization exists in this case. And in response to that reality, the respondents have alleged that they have the inherent judicial power to remove in absence of that specific legislation. This court, however, has guarded the authorization given to it under Section 4 of Chapter 211 closely. In Stowe versus Commonwealth, the court observed that a single member of this court, acting as a single justice, did not have the authority to remove a clerk in that regard. Also,
Are you distinguishing between elected officials and appointed officials here?
I am not, Justice Cordy. I believe that the fact that Registrar Campatelli is elected, as this court's own decisions have indicated, is deserving of a heightened deference from the court and brings other issues with respect to the restriction of voting rights to bear. However, I also believe that under the law as it applies in this matter and under the court's decisions, that suspension or removal still requires an action of this court under Chapter 211, Section 4.
I take it you also say that under Section 10C, under the clear language of 10C, the powers of the chief administrative judge and the court administrator are limited in what they can do vis-a-vis elected or appointed clerks.
I believe that's accurate, Your Honor. The legislature in a number of places has indicated the intent for that limitation. In the authorization giving the Chief Justice of the trial court under Section 9 of 211B, the legislature specifically stated that the Chief Justice of the trial court shall have inherent judicial authority, the very concept raised by the respondents, but then went on, as Justice Gantz noted, to say, provided, however, that that authority shall not encompass any powers reserved to this court. This court clearly has reserved to itself, and the legislature has reserved to this court under 211-4 the power to remove and the incident power to suspend.
Can any trial court judge order the removal of a disruptive clerk from the courtroom?
Certainly, Your Honor. In the inherent judicial authority are the concepts of judicial administration and rulemaking. The conduct of a court proceeding lies with the judge who presides over that proceeding. There should be no question that that judge has full control over that courtroom. That is not the question before the court in this proceeding, however, which is, does that judge or any of the respondents in this case have the power to suspend or remove that clerk? The answer to that, in absence of the specific legislative or constitutional authorization, is no, they do not. That power lies solely with this court.
Help me to understand what the authority would be of the Chief Justice of the trial court in a circumstance that we all can agree is not this one, okay? Imagine the most egregious, or at least a very egregious situation in which the clerk or the registrar is stealing money, is just stealing from the till. What would be the process to suspend that person with pay? How long must that person be allowed to remain in that position after there is a supported allegation of theft?
Not long at all, Your Honor. The removal should be immediate, as provided by this court's own Rule 313, which gives the Clerks Committee the power to proceed under Rule 7F immediately to this court. And the court has done so in Antonelli, 1999, in Duggan, 1993, in Powers, where they limited Mr. Powers' assignment in 2013. In all of those instances, there was first an action by this court to either limit the assignment or suspend that individual prior to the full adjudication. There's no reason for delay, and there hasn't been any cause for delay.
So it's not a problem for us to act preliminarily and then at the end of the day decide the case when it comes back before us after investigation?
Correct. Thank you.
Thank you, counsel.
Thank you, counsel.
Good morning, Your Honors. May it please the Court, Daniel Sullivan for the respondents, Paula M. Carey, Harry Spence, and Angela M. Ordonez. In this case, Your Honors, respondents assert that Chief Justice Carey and Ordonez have inherent judicial authority to place Register Campatelli on paid administrative leave. In the first Justice of the Bristol Division of the Juvenile Court, this court stated, the scope of inherent judicial authority includes the power to control and supervise personnel within the judicial system. In support of that statement, the court cited In re Antonelli, a case involving the misconduct of an elected register. The court described the judge's power to control and supervise court personnel as perhaps the least controversial of the inherent judicial authorities. The court stated that the power includes the judge's power to control the court's own proceedings, the action of officers of the court, and the environment of the court. I would submit to the court that in this case, Chief Justice Ordonez had credible reports of serious misconduct by Register Campatelli, that she spoke with at least one employee, and then thereafter an investigation was launched involving Dr. Corbett, who did a full investigation, interviewing 39 witnesses.
Mr. Sullivan?
And thereafter, the Chief Justice Ordonez, in concert with Chief Justice Carey and Court Administrator Spence, put Register Campatelli on paid administrative leave.
Has there ever been a case like this before, where an elected clerk has been placed on paid administrative leave, not by the action of this court, but by the action of another court administrator or chief justice?
I'm not aware of one, Your Honor, but that brings me to the point that my brother had suggested that this process could take place through the Clerks Committee. However, this matter was, first of all, the initial suspension of Register Campatelli was December 18th of 2013. The further suspension was on January 15th, 2014. This matter was reported to the Clerks Committee 2 days later. And
I thought it was reported in March.
in March, I'm sorry.
Yes.
I'm mistaken, but in any case, it takes time that's right, it was after the Corbett report, I apologize. So it takes time for these things to work their way through the Clerks Committee. And I referred to Justice Gantz's question, you know, we not only could we imagine a situation where a register was involved in theft? We've seen one, and this is the problem. The judges have to, the Chief Justices, I should say, have to have the ability to keep order in the court, to allow the court to continue to operate, to prevent the court from being used to harbor criminal activity.
Well, what about the flip side of that? I mean, there may be circumstances that are not difficult to imagine, in which the employees in a courthouse never liked the clerk before the person was appointed or elected, and now that they've been appointed or elected, they don't like them now. And they've concocted, now I'm not saying that that's what happened here, but that they've concocted some kind of a story, a grievance, and how are we to proceed under those circumstances?
Well, I think in that situation, I think the Chief Justice, in this case, Chief Justice Ordonez, had to make a determination on the evidence that she had before her as to whether or not these were credible allegations. I agree with you, but given the fact that the clerks and registers are elected, often there are people who hold over from the prior administration, and there may not be good feelings there. But in this case, the Chief Justice Ordonez looked at the fact that she found this registry not being conducted well, but in disarray, where the register was out of the office at least half the day, wasn't even showing up some days, where she was taking half a dozen favored employees with her on long smoking breaks, where she was using profane language in the registry within hearing of the public. You know, she wasn't plucked from nowhere. These were things that are credibly alleged against her.
Yeah, but they're not asking for a lot. Hopefully, this is at least the allegations are unusual. This is not an everyday occurrence. This does not involve moving one employee to a location where resources are needed on a temporary basis. This is a highly unusual set of circumstances, and all they're saying here is, given the nature of the employee's status as either a gubernatorial appointment or an elected official, in those circumstances, in order to accomplish what was accomplished here, it has to be done by a petition under 211, Section 4, or a complaint filed with the Clerks Association, with the committee. Why isn't that reasonable?
Well, the difficulty is that during that period, there's some employees have told Chief Justice Ordonez, and she believed them, that they were afraid to come to work, that they were in fear.
But we get petitions under 211.3, which is not unlike 211.4 in the manner in which they're filed. We get them quickly. We get them promptly. She could have gotten those allegations and filed a petition here herself.
Chief Justice Ordonez?
Yeah.
That would not have occurred to me, Your Honor. My thought was that the trial court should do an appropriate investigation and then proceed through the ordinary channel of the Clerks Committee. And that's exactly what we've done. The only question, as I understand it before the court, is whether or not during that period, during the interim, it's reasonable for a Chief Justice or all the trial court leadership to determine that for the good of the court, for the welfare of the trial court, it's necessary for the register to be on paid administrative leave, not suffering any economic harm, on paid administrative leave, so that the court can operate smoothly and efficiently until it's determined whether or not these allegations, which have been very thoroughly investigated by Dr. Corbett, are indeed true. And I just think that the balance the balance weighs heavily in favor of making sure that Suffolk Probate and Family Court can operate, as opposed to whatever minimal harm there may be to Register Campatelli by being on paid administrative leave.
And that couldn't have been done by 211.4 petition.
Well, 211.4, it refers to, it's not clear to me that would have been a proper way to proceed. It seems to me if the trial court brought a 211.4 petition to this court, it would be ignoring the Clerks Committee process.
And it would surely have to have, 211.4, presumably, that's the dismissal power that we have.
Right.
The termination power. So you're saying the court's not ready to do that. The court has got concrete allegations of some specificity, and it has an obligation to investigate them and needs some tools.
Yes, Your Honor. There's been no suspension with pay. I mean, that's it. The 211.4 is really about dismissal. It's only by virtue of the McGonigal case that we know that it subsumes the ability to suspend. But I just want to say briefly, it's not clear to me that that's an exclusive authority.
Yeah.
This case, in the Powers case, this court said that that's the sole authority of this court.
But it was talking about removal at that point.
Right, and it refers to the Turner case. And I don't find in the Turner case any statement that it is the sole power of this court. And I think particularly with respect to suspension, that becomes relevant.
Could I ask you about, moving away from inherent power to the statutory 211B and the
Yes, Your Honor.
statute? Your position, well, let's start first with Chief Justice Carey. And Justice Gantz says there's no specific, well, where does she get her authority? Because I don't see one of these Romanettes, I've never heard that word before,
Nor did I.
referring to suspension or dismissal.
That's correct. And in the case of Chief Justice Carey, I rely exclusively on inherent judicial authority. There is no provision in her statute to suspend or dismiss.
So, and if you're going to use a Romanette, you would go under 23, the last one.
That's correct,
Okay.
yes.
So then, moving on to, I'm going to move on to Chief Justice Ordonez.
Thank you.
So she is 10-6,
Yes.
right? And that has this, as Mr. Boncory has said, the last clause of that subsection says, provided this provision shall not apply to a clerk or clerk magistrate, whether, et cetera, or register of probate. So you say that proviso applies, I'm trying to figure out where you say that applies. You say it doesn't apply to the whole power in that subsection, but it applies to part of it. And
Yes, Your Honor.
which part is it?
It applies
that
to
you
the
say?
sentence which contains that proviso. My position,
About transferring records, that's it?
right, well, those are the rules of English grammar. If you have a clause that's attached to a sentence, it applies to that sentence. There's no way to read that in accordance with what we think of as plain language and say that it applies to the previous sentence.
There are
The legislature may well have intended that. I don't say that they didn't, but the way the statute's written, the words on the page indicate that proviso applies only to the sentence to which it's appended.
So are you saying basically that Chief Justice Ordonez not only has the power to suspend, but the power to dismiss?
Although that's not before
elected
this
register?
court, I think there's an argument to be made there.
Under the statute, that she was given the power to suspend and terminate?
We don't press that. That's not our primary.
I understand that, but I mean,
primary-
it's a natural
I
reading.
think
If
that
you're
that's
saying that the proviso at the end doesn't apply to anything that precedes it, other than that, the records-keeping function,
That's correct.
then it would also suggest that she has the power to dismiss.
That's the logic of that argument, and which is one of the reasons I raised the idea that it's not clear to me that 211-4 gives this court sole authority with respect to suspension.
Could I
or-
ask a
or,
little
for that matter, dismissal.
further question about that last? It does seem a little strained to say that it's only about records, but the preceding sentence and Section 1 under Section 10 limit the power of the Chief Justice to transfer any person. First, it says any person can be moved except a register of probate and others. So doesn't it make more sense if you're going to, I get your argument, you don't want to expand it beyond the sentence because the proviso is with respect to that sentence, and normally under construction, I understand your argument, you would only look to that sentence. But it speaks to records, which is a little strained to say that it's just records, but the preceding sentence and another provision in that same section do limit transfers. They can make transfers, but not with respect to registers and clerks. Is that a possible reading?
Well, I think that is distinguished from Your Honor because it's really, the power on transfers is concerned with the fact that a register is either elected or appointed to a particular court.
Right.
And therefore, that the Chief Justice shouldn't be interfering with that appointment.
Right.
However, if in the operation of the court, the Chief Justice determines this is wreaking havoc, the court can't operate properly, given the misconduct of this clerk, I need to be able to step in and put her on, as in this case, put her on paid administrative leave while we investigate. And that's all that's happened here. I understand this argument is hypothetical in this case, I would say.
In powers, one of this isn't ultimately, the decision here was about removal, I understand that, but along the way, if I'm recalling correctly, Chief Justice Connolly I thought, directed Mr. Powers to sit in another court, to transfer to another court. This was before this statute was enacted. What was that inherent authority that you say?
I mean, as you say, it predated the statute. I think that at that point, and I don't know, but I would think that Chief Justice Conley believed that that was within her inherent authority to enable, because the Clerk Powers was creating serious problems in that court, as this court is aware. And I think Chief Justice Conley thought, again, for the benefit of the trial court, for the benefit of the public in the trial
There's
court.
an inherent authority.
There's inherent authority to remove someone, at least temporarily, pending the Clerks Committee proceeding and the proceeding before this court, in order to avoid chaos from reigning in the trial court.
What do you say about your brother's argument that this has disenfranchised the voters who elected the registrar?
Yes, Your Honor. I think that the thought there is that really that elected office is not unimpeachable. And that's why we have these processes in place, the Clerks Committee and 211-4, to enable this court to look at a situation deliberately and say, look, we've looked at the evidence, we've heard from the registrar, the clerk, and we're going to determine that this is so far outside the bounds of acceptable conduct that we're going to remove that person, as happened in Clerk Powers' case, for example. I think that's the sufficient safeguard from the will of the voters being subverted without just cause. It can't, I mean, even the President of the United States can be impeached. The notion is that because you're elected, it doesn't mean you can engage in misconduct and illegality freely and mistreat your employees, and that there's nothing anyone can do about it.
No, but the statute provides that such an official can be removed just by us, not by someone else. So there's no question that the voters can be disenfranchised in that respect because we have the power to remove.
And I think it's understood there that this court would not remove without having a hearing and engaging in appropriate due process. And by the way, under the authority that we proposed under Section 10, 211B10, the notion there, of course, would be that there would also be due process in by the Chief Justice if she were to engage in that action. No one's been suspended or dismissed here. I would say that if a Chief Justice, even under that 21110 Roman 6 power, were seeking to suspend a clerk, you'd still be subject to the Loudermill standard. You'd still have to provide appropriate due process before taking that kind of a deprivation of property.
What about Mr. Spence? He operates under a statutory scheme that gives him some powers of removal as well. And does he have the power independently? He has no judicial authority.
I had advanced...
Give him the power to do this too?
Well, I had advanced that argument, Your Honor, before the single justice, with Court Administrator Spence's approval. Within a couple days after that, he reconsidered and said he wants to pursue the new Clerks Committee proceeding, and he believes that that procedure will give all the appropriate stakeholders an appropriate role, an appropriate voice in making these determinations. So as a consequence of that, he asked me not to press that argument on his behalf.
Now, your brief makes no reference to 211B, Section 10, capital C, because?
Well, this is, and this is where the statutory power may come in, and the idea that 211.4, as I suggest, may not be the sole power of this court, because 211C closes with the phrase, except as otherwise specified. And I think that statute creates some authority that's specified by the legislature.
But doesn't that statute certainly speak to a legislative intent to be very protective of elected and appointed clerks?
Well, I guess I have to rely on that final clause, Your Honor, and say, when it says except as otherwise specified, and in addition to that...
You mean except where expressly authorized? Is that what you mean?
Yes, Your Honor. Yes, Your Honor, thank you. In addition to that, I mean, I have to, the inherent judicial power in this case of paid administrative leave, which is a fairly minimal action, may not constitute any interference with that statute. We're not really significantly interfering with the clerk's ability, the registrar's ability to do the work of the Commonwealth. We're just asking her, as if it were a stay in litigation, to stand aside while we investigate, give you appropriate due process, determine whether or not these allegations have any substance at all, and then on that basis, if we have to refer it to the Clerks Committee, we will. But during that period, rather than having someone engaged in criminality or otherwise acting very inappropriately in the registry, we'll ask you to stand aside on paid administrative leave while we make that determination.
Thank you, counsel.
Counsel, your time is up. Thank you very much.
Thank you, Your Honors.
Thank you, Your Honor.
Thank you. Yeah, let's let people leave.